Hello, my name is Anne. This is Group 1. We are the industry group. Sorry, the law firm and private practice. Back to basics. So we're all from different law firms or national offices. And I guess I'll start by a general disclaimer. I think we can fairly say none of our opinions should be understood to be our firm's opinions or our office's opinions. But here we looked at some of the different trends from the IP monitor, and we looked at how this came up in our practice. And so we're each going to present a slide on what is most relevant to our practice. So I'll start off with U.S. litigation trends. I work as a litigator in the United States. Some of the things that we've seen in terms of, I guess the trend that it relates to is IP as being key for recovery, similar to maybe the 2008, 2009 time period. We are seeing an increase in the number of IP cases that are filed in the US. That includes both patents and trade secret or know-how cases. The trade secret and know-how cases may be a little bit more to do with COVID-19 and merging of work and home in terms of devices and environments, why we might be seeing a little bit more of an increase of those. And then also, this is the second point, companies are sometimes without maybe a longer range strategy, finding themselves in a not so great economy and looking to mine their portfolios and see what they have and what can they do with what they have. And the last thing I'll say is we've also, I think, noticed that some of our clients and our companies can be a little bit more aggressive. That can mean less willing to settle and really wanting to go to trial, maybe making decisions a little bit more emotionally, and just being able to notice that and counsel them through it.
Hello everyone, my name is Thanh Thúy. I'm currently working at WIPO, and today I would like to introduce the IP chain at WIPO that I observe and how we cooperate with partners, develop the eco IP system to become more efficient and to help the clients to with a better life and more sustainable future. And what we are going to do and we are currently doing and going to do, that is we cooperate with member states and intergovernmental organizations and stakeholders to promote the importance of IP and to promote the innovation and creativity to raise awareness of the knowledge about IP and the potential of IP system for society. And we bring people together and to shape the future of the global IP ecosystem by developing balanced and effective international normative frameworks for IP. So WIPO becomes forum for exchange of information and experiences. So we convene leading discussion on IP. We also cooperate with member states and private and public organizations to build respect for IP. We engage with the United Nations and other IGOs and non-governmental stakeholders in supporting of global goals to which IP can contribute. So to promote collaborations and to make it more efficient, we are working to provide a high quality IP services, knowledge and data. And we increasingly digitalize IP management platforms and tools with data-driven systems. And we are improving the productivity and service quality. We also facilitate knowledge transfer and technology adoption. So collaboration, it also includes the supporting of governments, enterprise, communities, and individuals to use IP as a tool for growth and sustainable development. So that's all from my part.
Hi, I'm Daniel. I work for the European Patent Office. And one of the findings in the IP Trend Monitor was that the IP offices like WIPO, like the EPO, have gotten better at dealing with the implications of the pandemic. So that is notably an outside view. So users of the IP system think that the offices have gotten better at adapting to the post-pandemic situation. But I want to complement that with an inside view. Have we actually changed anything? And if so, what does the staff think about it? And the quick answer is yes. So we have coined a new term in the EPO buzzword space. We call it new ways of working. And what is most visible to our users may be that we are now holding oral proceedings as video conferences as a default. But there are also some internal changes that are not so visible to the outside. Let me start with, like, before COVID, we had such nice paper files. Each and every application would go into such a paper file and it will come to my desk. And once you eventually wanted to grant a file, you stamped it and you signed it off physically. It went to the second examiner with the internal post, signed it off, went to the chairman, signed it off, went to the formalities officer, and out it went. Several initiatives have been trying to kill this paper file. So we did have computers at the office before the pandemic already, but we had like this paper file, which was authoritative, and a digital twin that we worked with. But the workflow was driven by the paper file. And we've tried to kill the paper file for 20 years, but only it was not until COVID that finally managed to do that within a week. Oh, sorry. So the paper file was dead when nobody came into the office anymore. And what happened was we started with patchy workarounds and then more isolated solutions. But by now, over 2 years, we do have a full new end-to-end electronic workflow tool chain that is cohesive and that we can really work with. We have also gotten new hardware. We used to have desktops and thin clients, but now we all have laptops and iPads, and we can practically work from anywhere. We also have a new working regime. So we have to work at the EPO premises for 60 days a year, but the rest is flexible. So I can decide every morning whether I want to go into the office or not. And I can even work 60 days per year from any EPO member state if I want to. One of the more critically seen developments is also that we are moving away from fixed workspaces in the office. So up to now, each and every examiner used to have like his own desk, like with a picture of your spouse or your girlfriend or both. And that's not going to happen anymore. People used to bring in plants or refrigerators or pianos, and all you have now is like a pool of workspaces and a little locker that you're getting. We will see how that will be accepted. In any case, overall, we also do an EPO staff engagement survey every year where we ask people about certain development. And you can see that most people believe that the collaboration has become better, and most people also believe that the effectiveness of remote working has become better. And insofar, the inside view is consistent with the outside view. So we also think that we are less bad than we were before. Thank you.
I'm Melissa, and I'm a lawyer, and I currently work for more than one law firms, and I handle the IP cases. Maybe I'm being too short, but I noticed two trends, and one of them, my colleague will talk later about that. However, internal trend and external trend. Internal trend, there is I'm looking for professional with high skills and high specialization. And for instance, I work with trademark, and in Italy, which is where I come from, there is a high interest for this. And about external, in the small, medium enterprises, which is my area, are very, right now, are starting to be interested in IP field, and especially in how they can protect, obviously, their interest. Sorry if I'm talking about something. And on the other side, there is an increase in the case filed. And I would like to talk briefly about small, medium enterprise, because right now there is starting a vision not only about the present, but about the future. So they are using trademarks, especially because this is what I deal with, to boost their activities, but also they look towards the future to see their process in the future. And this is it.
Hi, my name is Larry Bond. I'm a private practitioner, patent attorney in the United States. Of all of these here, I think probably the first one requires the most attention, so I'm going to concentrate there. The rest of them probably go by the wayside. In my state, in Utah, about 3 or 4 years ago, the state, including the Attorneys Association and the Supreme Court, did a survey. They found out that 84% of the people in Utah could not afford lawyers. 84%. Only 16% of people in my state could afford legal services. You can imagine in an industry that is so affected with public interest, that result was extremely disturbing. And so the state took a very, very proactive effort to address that, the results of the survey. And they resulted in what's called the sandbox. It's the first state in the United States to implement these kind of practices. Essentially what they did, implicit in that is essentially the recognition that the legal profession has somewhat abused its monopoly. And therefore, they're going to try to change that. So what they tried to do is shift law firms from a more of a monopolistic position over to a general business proposition. For example, in Utah now, partners, owners of law firms no longer need to be lawyers. You could have a law firm that's completely owned by non-lawyers. Extremely disturbing through a classical mindset about law firms. Also, many of the legal practices that historically have been restricted to lawyers are now open for non-lawyers to do. You can understand that, say, in areas like family law, collections law, things that affect a wide subject to the population. That's completely understandable, but they didn't limit it to that. IP also came into that mix. And so what you have now in Utah is a vast number of private companies, not law firms per se, private companies offering legal services, and they're offering it through nationwide advertising, specifically in the intellectual property area. And what it has led to is, I would call it a commoditization of legal services in the IP area. So now what you're seeing is, for example, trademark applications. If you come to the United States, a typical cost for a trademark application, attorney's fee side of it, $750,000. Now you're seeing these companies showing up in Utah, private companies, offering trademark applications for $500. They're completely undercutting reduction on the normal cost of a law firm for that same service. Now, what they're going to do is they're going to have those services done not by a lawyer, an in-house lawyer within that firm. They're going to outsource it to, in effect, independent contracting lawyers. And the constrictions they place on that outside lawyer, in my view, are amazing. Because what they're going to do is take that $500, they're going to keep $250 of it. They're going to give $250 to the lawyer now. Now they're going to place restrictions on you. In order to get that $250, what you're going to have to do is you're limited to 20-minute conversation with the client, 20 minutes only. Cannot exceed 20 minutes or you will lose the contract. You must file the trademark application within 2 days of receiving it. Okay, you fail to do that, they'll take the contract away from you. And the third thing they're going to do is they're going to say, in exchange for getting this contract, you've got to commit to spending 4 hours a day answering questions for our subscribing clients, intellectual property related matters, for free. So now you're dedicating 4 hours of your day to answering, typically it's copyright questions, which, as you all know, is very difficult to attract any kind of legal fees for, because they're typically questions that are not. So now, in effect, for $250, you've now limited to 20 minutes, 2 days, and 4 hours non-compensated conversations. Can you imagine what this means for a private practitioner? But this is the result. And the reality is I worked for one of these companies for about 2 months, and it was absolutely incredible experience just to see what it was like. And what happened is due to this commoditization, this reduction, they were getting calls and cases from all over the U.S. Because trademark practice in the U.S. is in effect national practice. You're dealing with the U.S. National Trademark Office, so you can file them from anywhere. So now you're getting casework attracted from all over the United States coming into Utah, and then you do that at a reduced rate under these kind of conditions. It's absolutely a total talk about disruption. This is disruption, in my view, at the highest magnitude in legal practice, and it's only started. A lot of other states now are looking very positively at these things and starting now to adjust to it and adopt their own version of it, which you can imagine what the end result of that's going to be. To me, it is a whole new world. And one would think that intellectual property practice would be somewhat isolated from this. It's proven not to be the case. And you can imagine patents, they're doing the same thing with patents. And so in effect, the core business of private practice in intellectual property is now becoming under major, major pressure for cost reduction. You're now looking at things that are being much more reduced as far as your opportunity to counsel with clients. I mean, I look at a lot of what we're doing here, and I'm trying to figure out how would that work under this kind of model, because a lot of your base practice now is being taken away, and now you're trying to, in effect, market legal services that are more counseling, and how to do that in the present environment that I'm seeing in my state. It's going to be extremely difficult challenge, and we're talking about orders of magnitude as far as trying to adjust to a different business model.
I am Jacob. I'm a European and UK patent attorney. So a large part of the report was also about ways of working more efficiently. And I thought, well, I would sort of play off Daniel's bit earlier about the EPO and talk about how we've changed in private practice. So I'm somewhat encouraged to hear that the EPO was similarly old with us with paper files, because we also had paper files. We printed off everything, had an old paper spec. We used to handwrite amendments and pass it off to be prepared by the paralegals, and then it would get filed and whatever. Not just that, we would also print off every email we got and put it in the paper file, and it was ridiculous. So recently, as I'm sure it is quite similar across lots of industries, there's a much more efficient shift towards video conferencing and remote working. That's not only due to COVID-19, but I also see there was quite a lot of waste in our previous ways of working with all the paper, not only paper costs, but as we've talked about, sustainability is profitability. And we've really noticed recently that a lot of new tenders, they are requiring for sustainability reports and what you're doing. So we've recently signed up in our firm to more and more advisory situations where they give you a report every year and encourage you as to how you are dealing with your emissions or your wastage. And we're finding that very useful in not only efficient ways of working, but also in pitching for new work. So yes, that's a little bit about our internal changes, but there's also a change resulting from this in our offering to clients. As we heard from Daniel earlier, the EPO hearings are now online, which for a company that has a lot of multinational clients makes it incredibly easier for them to also attend in their way. And that is a way that we can offer to add value, in that they can really see our side of the situation, and it's really helpful in showing them even if you get a negative result, it's not necessarily the way that we've done it. In addition, it's a lot more easier to be a lot more flexible with your clients. You no longer have to go and sit with them and discuss everything with them. Whereas you can say, oh, are you free in 15 minutes? We'll have a quick call. And also that has the secondary effect of making it easier to keep records. We find, like here, we can record meetings if we need to, and people can refer back to that when we need. And this comes on to the last point, where the report was quite strong in saying that most respondents, in fact, only a quarter of respondents, still said that face-to-face meetings are still important. I think that somewhat goes against my experience, that I think they're not less important, they're just less frequent. And actually, the opportunities you do have to meet face-to-face are actually more important, as people make more of a note of it. And particularly for driving new work, we've found that really is a way we can differentiate over purely virtual meetings. You just have to be a bit more smart and efficient about the way you organize them. And for example, we will no longer fly to a city for a day. That goes against our sustainability objectives. But if we are around, we'll make an effort to contact all of our clients and then really go through with them what we can offer them. And that drives new business.
Okay, so my name is Guy, and I'm actually I have my own firm called Intellectual Design Group, or IDG, and I have offices in Thailand and Japan, Singapore, and Myanmar. So I want to talk a little bit about the Southeast Asian perspective. So Southeast Asia, or ASEAN, is actually quite a big continent and region. It's going to be probably the fourth largest economy by 2030. And here are some trends that I actually believe that's going to happen. Looking at the current state of the firms in Southeast Asia at this point. So at this point, the IP firm practices in Southeast Asia, like more IP firms are pretty much local, and some overseas firms are establishing around the region, like in Thailand, Singapore, Indonesia, Vietnam, Philippines, and so on. And there are more presence of Chinese IP firms coming in as well, as there are more filing coming in from China. And most are still offering the same type of services, though, in terms of IP prosecution, patent, trademark, and so on. Very little differentiation, which leads to a lot of cost cutting amongst themselves. So very cost conscious battlefield over there. And a very small number actually are offering IP business consultancy services like valuation, licensing, commercialization, and so on. So I think that the skill set that will be required in the future would be that, I think at this point, a lot of patent attorneys in general that I know of are mainly legally trained and have very little technical background in general. So I think that by them having more technical background and coming to a legal background later on would be very important. So that they can understand the language of science and technology, and will become more important for them to understand the nature of technology and talk to their clients in the R&D or corporate IP practice a lot better. And there are probably more need of non-IP legal practitioner to bridge the gap between protection and commercialization. So jobs like IP evaluators, licensing strategists, tech transfer specialists, and so on, will become a lot more important as more IP owning entities are looking for ways to commercialize their IPs, not just protecting them. So I think the image on the right side here is actually very small to see, but it's a skills framework. It's pretty much developed by IPOS, the Intellectual Property Office of Singapore, and pretty much they set a framework to actually for you to actually see different career paths that you can actually obtain in this IP industry as a whole. So there's a set career path if you want to become like patent agent or attorney, or set career path if you want to become IP evaluator. Actually, right now in Singapore, as far as I know, for the past 2 years, they've been working. The IP people they're working together with the Singapore Stock Exchange to actually create intangible assets valuation standards. And they want to be able to evaluate intangible assets in all publicly listed companies. So they're going to use that standard to also do valuation, providing services to a lot more SMEs as well. So we're going to see how that goes. So yeah, there are many different career paths, not only becoming a patent agent or attorney anymore. So you can become an intangible asset valuator and so on. So yeah, that's how it shaped out, and I think that we'll see how it goes for Southeast Asia.
Good morning, everyone. We are bringing you to Southeast Asia, and now I am in the Philippines. So we are in Asia. Okay. First and foremost, I'm a businessman and a lawyer. I'm also a certified public accountant, and I'm teaching IP, tax law, labor law, and commercial law. I would like to start with the IP courts in the Philippines. We are now online except when there is a need to present evidence. With regard to IP lawyers, there is a big need for reorientation. Why? Because most lawyers in the Philippines are not aware that IP is strongly connected with business. So there must be a reorientation that we must do. And they are not, I think they are not conscious that IP has to be converted to wealth. And that wealth must be brought to income statement, balance sheet, and of course, finally as dividends to the stockholders. I would like to change that mindset that lawyers are not for business, because that is the common understanding that lawyers are poor in business or they are not good in business. So I think they need to change that already, and we need to do that in the Philippines. I think not only in the Philippines but also worldwide that the IP practitioners or the lawyers must be strongly connected with the business objective of the organization. As a businessman, personally, I would like to have that because it was an eye-opener for me as well during the past 2-3 days that economy now is highly dependent on IP technologies. And I would like also to emphasize that there is an insufficient conveyance from the IP authorities in the local economy, that there is a substantial development in the intangible assets as a result of progress in the knowledge economy. That's all. Thank you.
Hello, everyone. My name is Victor Lasarenko. I'm Russian immigration patent attorney working for Autentica, which is an intellectual property law firm providing patent prosecution, opposition, and litigation, IP prosecution, opposition litigation services in Russia and Eurasian region, as well as some neighboring countries which are not parties of the Eurasian Patent Convention, such as, for example, Uzbekistan, Georgia, and Ukraine. So having read the IP radar, I found many trends actually, which I think are very relevant to across different jurisdictions, but they're also true for Russia. For example, Jacob already mentioned that it's adapting to work online and remotely. We meet with clients online. We have this possibility to attend oral hearings at the Russian Patent Office, Eurasian Patent Office, IP court online. So we meet with clients and we don't have this face-to-face meetings mostly. So we use webinars instead of seminars for educational tools. So the main point here is that we need to adapt to do it with the same efficiency as we used to do it before the COVID. So there was a question about which language sets are important for the IP manager. And here is I think we have the increased importance of software and data processing tools for law firms in Russia. For example, on a daily basis, we provide a lot of translation, mainly from English into Russian. And so before the COVID, we started to use this software, machine translation, which is a self-learning memory. And actually it helped us to, first of all, to minimize the cost of translation for our clients. At the same time, it also helps to provide more accurate translation, especially when it comes to patent applications with from the same technical field. So the first question that was asked in the IP radar. So what do you find the most challenging part of the work in IP? And here I agree with I don't know, 50% of respondents who answered that promoting the importance of IP in developing IP strategies for the client to understand what they really need, from which sector, from which industry they came, and how to provide competitive advantage and to make it sustainable is the most challenging part. Absolutely agree with that. So now I cannot help mentioning the subject about the war, which I hate very much. I have relatives in Ukraine, we have business partners in Ukraine, and it's last catastrophic for us, frankly speaking. But of course, there are certain trends which are associated with this topic. And what is the main trend for us? We represent clients both in Russia and Ukraine, and we feel this need nowadays to inform our existing clients and maybe some potential clients. It can be this way too. What is going on actually, and what is going in the IP sector in general. So, in a few words, during 2022, like a quarter of the Western companies hold on. Either cancel or put on hold the business activity in Russia, and that provokes a lot of mergers and acquisition deals, rebranding activity, and logically, very logically, the number of patent applications filed to the Russian Patent Office dropped, probably by the same number, like 25, 30%. So at the same time, we see the increase of the interest of the Eurasian patent, because it can help to protect and provide protection in the neighboring countries, in seven neighboring countries in addition to Russia. And these countries are believed to be the hubs for importation of Western goods into Russia. And that's why it's very important maybe to protect there, because it's out of question that Russia is very dependent on the technological products, and this is absolutely out of question. There is a lot of also disinformation about the IP litigation in Russia, I would say, because we are close, we keep a close eye on this subject as well, and we see that still, when it comes to clear acts of patent infringement, the IP court takes the decision in favor of the Western IP owners. And we had these cases to list them in order to use them as proof and to show that that's actually it's happening. So, and I think we continue this way. So last point, the Ukrainian Patent Office, the Russian Patent Office, Eurasian Patent Office, IP Court, and all the administrative authorities work pretty much the same way as they used to work before. So people are adapting, life goes on, and this is probably it in a nutshell. Thank you very much for your attention.
Last one, don't worry. Hello, everyone. I'm Leonor from Denemeyer, so the authors of the IP Trend Monitor, which we were supposed to read. So we thought it appropriate that I be the one presenting any overlooked trends, and I would only highlight one, since we are all hungry and think we want to get out of here as soon as possible, and that's ever faster technological progress. So the trend is maybe already a bit out of date, the trend monitor, because it was written back in April when we were all more focused towards the pandemic, whereas today the WHO is already considering declaring the pandemic over. They're discussing it at least. Ever faster technological progress creates a need for me as an IP expert, a trademark lawyer, to become an expert, or at least to become knowledgeable in a multitude of fields. I need to understand the metaverse, which I don't understand clearly yet. NFTs, AI, those are the questions which clients come to me. And there is a huge time gap between the technological progress which is happening and what the offices and national jurisdictions are doing. We had a multitude of NFT filings, NFT-related filings, and with the EU IPO, well before the EU IPO announced that it would go into Class 9. We didn't know where to put it. So there is that time gap which affects us. Our clients demand answers, and that has a significant impact on us because we are not sure how to answer them. Do you file now or do you do not? Do you need to file even, or will it be considered similar if I sell a Volkswagen, let's say Volkswagen car in the metaverse? If I'm covered in Class 12, is that enough or not? So these are the questions which we don't have answers still, because we are waiting for the public authorities to do their bit in all that. Thank you.